Hi, everyone. Welcome back. We're going to finish up the week talking about the New York sex offenses. So in the last class, we went over the common law definition of sex offenses. This time, we're going to go look at specifically New York and how New York decides what the sex offense should be. Okay, so let me share my PowerPoint with you. Start it. Okay, so we spent the last class talking about the distinctions between the different levels of sex offenses. Now we're going to look specifically at the New York sex offenses. Now, when you're looking at New York, definitions are really, really important when it comes to sex offenses in New York. You have to fit the definition of certain terms if you're going to fall under certain sex offense laws. So what I want to do real quick is look at section 130. So you can pull out your books and you can look at section 130. So section 130 gives a lot of these definitions. And so some of the things that we talked about, you'll see in these definitions. So the first one is sexual intercourse. When we start looking at New York for rape requires sexual intercourse. Rape in New York only is sexual intercourse. So if it's any other sexual conduct like oral or anal sexual conduct, touching, that will not qualify as rape in New York. So the law specifically says sexual intercourse, and just like we talked about in class, that means any type of penetration, however slight. So it can be just a small amount, but if there's any penetration, that then becomes sexual intercourse. And then in New York, you can charge you can charge rape. Now we have other crimes we'll talk about in a minute that's going to be criminal sex acts. So it's not like you just go free just because you don't have sexual intercourse. If it's a different sexual act, like oral or anal sexual conduct, then you fall under a different crime. Same level, same class, so same punishment, it's just a different crime. In New York, it's criminal sexual act, and that includes oral or anal sexual conduct. So you can read those definitions and you can see what is included with those. Sexual contact, just sexual contact means any touching of a sexual nature or intimate parts for the purpose of gratifying sexual desire. Okay, so that is one of them, and you can read a little bit further about it. And then the ones that are going to be really important later that we're going to talk about is mentally disabled, means a person suffering from a mental disease or defect, rendering them unable to appraise the nature of their conduct. So this would be sort of like the insanity test, right? So you have a mental disease that affects your ability to basically know what's going on or appreciate the conduct. A mental incapacitation means a person that is rendered temporarily incapable of appraising or controlling his conduct owed to the influence of narcotics or intoxicated substances administered to him without consent. So if you are involuntarily intoxicated, if you were drugged, then that is mental incapacitation. And that's going to go with the idea of consent, which we'll talk about. And then physically helpless means you're unconscious for any reason and physically unable to communicate your wishes. So if you're completely passed out, and then obviously that's more physically helpless or in a coma or anything like that. Forcible compulsion means to either use physical force or a threat of some sort of a force. So we'll talk about that. Some of the touching offenses, we'll talk about foreign objects. So those are the things that you can see. And then you'll see aggravated. So aggravated usually means that there's some sort of an object that is used for the touching. So those are very important definitions. So when we start going through the PowerPoint, you have to understand what those definitions mean. So these were some of the ones that I listed. So make sure you understand these definitions. Now, when we look at the actual New York sex crimes, they can be broken down into three main categories, okay? So if it's a touching offense, so if one person is touching the person or intimate parts of another person, in New York, it's either going to fall under what we call sexual assault or touching, forcible touching, okay? So those are going to be the touching offenses. If you are talking about sexual intercourse with penetration, that will fall under rape. And if you are talking about anal or oral sexual contact, under common law, that was called sodomy. But in New York, we're going to call that criminal sexual act. Okay. So what exact contact has to be, exact contact was made will affect which crime you charge in New York. So if you're an investigator for one of these crimes, you have to know specifically what happened to the victim. So you're going to have some sort of conversation with the victim, and they're going to have to, they can't just say I was sexually assaulted. They have to specifically tell you the contact that was made, and that will help then narrow down which crimes you're going to choose. So if it's just a touching type of offense, you're going to be under criminal sexual assault or forcible touching. If there is the sexual intercourse, you would choose rape. And if it's oral or anal sexual contact, then you would choose criminal sexual act in New York. Now, we have multiple degrees of each of these crimes. So we have to figure out what are some of the factors that affect which degree that we would actually ultimately choose. And these are some of the factors that you're going to have to look at. The age of the victim and the perpetrator. So when you look at rapes, criminal sexual act, the perpetrator has to be over a certain age and the victim would have to be under a certain age. Usually it's a 4-year gap. So a lot of people think, oh, statutory rape is my boyfriend turned 18 and I'm still 17. That's not really how it works. When you look through the different degrees of rape, you will see that there's usually a 4-year gap, 21 under 16, okay? So you will see those kind of gaps. Use of force. Was it forcible compulsion? Was there some sort of force used to do the sexual act? If you are using some level of force, you're going to be at the highest degree. If there was no physical actual force or threat of force, then you won't be in first degree. And then the last one is the victim's lack of consent. So you always have to show that the victim didn't consent. But why didn't they consent? Because they were incapacitated, because they were mentally disabled, because of their age, because they were intoxicated. So you have to know the reason why they did not consent. And that can also help you narrow down which degree that you would also ultimately charge in New York, okay? Now, we need to look at this lack of consent language a little bit, because this becomes very, very important when we're talking about sex crimes. All sex crimes require lack of consent. So I'm going to quickly go back to that page that I was just on, and we can look at, maybe, if I can find it. Where did it go? Oh, I think what happened was it got switched off. Okay, let's try this again. Okay, so when you scroll down, I'm just going to scroll down, then we get to the lack of consent section. So it says, whether or not specifically stated, it is an element of every offense defined in this article. So every sex offense that the sexual act committed was without consent of victims. So that is a required element for every sex offense, no consent. So whenever you list your actus reus, make sure you list lack of consent, because this is saying that every sex act also has, the prosecutor also has to prove lack of consent. So we need to talk about what meets lack of consent. What does it mean to have lack of consent? So we look under number 2, it says forcible compulsion. So we defined that already. If you use force or threat of force, that's forcible compulsion. Then you can charge any of the crimes by showing lack of consent. So forcible compulsion shows lack of consent. Inability or incapacity to consent, or where the charges is sexual abuse or forcible touching, in addition to forcible compulsion or incapacity of consent, in which the victim does not expressly or impliedly acquiesce to the conduct, okay? So incapacity to consent, or the victim, if it's a touching offense, they did not expressly or impliedly acquiesce or want the conduct to occur. Now it says where the offense is rape in the third degree or criminal sexual act third degree, in addition to forcible compulsion, circumstances under which at the time of the act of intercourse, oral sexual contact, or anal sexual conduct, the victim clearly expressed he or she did not consent to engage in such act, and a reasonable person in the act or situation would have understood the words and acts as an expression of lack of consent. So if the person formally says, I do not consent, then that qualifies as lack of consent. Okay? Or even if they do something and it's very clear that they were not consenting. Now, what does it mean to be incapable of consent? So up on number B, we said incapacity to consent. So what does it mean to be incapable of consent? Well, our law says if you are under 17, you are incapable of consent. So 16 and younger, you're incapable of consenting to sexual intercourse. So if somebody under the age of 16 engages in sexual intercourse, they could always claim, they could always claim that the victim did not consent, and it could be a sexual abuse, sexual assault case. Mentally disabled, so we talked about if you have insanity or if you have a mental disease, it could be an intellectual disability that keeps you from understanding what's going on, then you have lack of consent. Okay, we talked about mentally incapacitated. So that was if you were voluntarily, involuntarily intoxicated by drugs or alcohol, then you can't consent. If you're completely physical helpless, you cannot consent. E, if you're in the care or custody of a supervision of a state Department of Corrections or community supervision or a hospital. So if you're sick in the hospital or you're in a prison facility, you cannot consent. So inmates can never consent to sexual intercourse, okay? If somebody's released to community supervision, so like a probation type of thing, they cannot consent. If somebody is in a mental health facility, they cannot consent to sexual intercourse with anybody that works within that facility. Okay? If you work in a correctional facility, the inmates can never consent to sexual conduct in a correctional facility. Okay? Or if you're committed to the care and custody of any correctional facility, you cannot consent. Okay? If a child is placed in the Office of Child and Family Services or residential care, they cannot consent, also their child. A patient or a client of a healthcare provider, so psychological healthcare providers, we have different offenses that they cannot consent to. So those all go to what you cannot consent. So remember, for all sex offenses in New York, you have to show lack of consent. And those are the rules that you're going to follow for lack of consent. So always keep in mind section 130.05 when you're trying to decide whether or not there was a valid consent. Now, what's interesting is this came up just a couple of years ago. The district attorney of Manhattan came out and said, if a woman or man is intoxicated voluntarily, they themselves decided to drink or do drugs, then the prosecutor cannot show lack of consent. Since they voluntarily drank or did drugs, then that negates the lack of consent because they can't not consent. What the law has said basically is if you're that drunk, you may not remember that you actually did consent. So we're not going to prosecute people for those offenses. Now, remember, if it's involuntary intoxication, it's different. And if you're completely physically helpless and passed out, that is also different. But if you choose to voluntarily become intoxicated and then have sexual intercourse, you can't claim lack of consent. Now, this is very, very, very controversial because there are times that people have been very, very drunk, maybe not physically helpless, but beyond the ability to consent. And the idea right now is the way that New York's law is written, they can't claim rape. So there has been a push in New York to try to change the law and not make it just be involuntary intoxication. Okay, so now we talked about lesser included offenses in New York. So if you cannot prove criminal sexual act or rape, you can drop down to a lower offense in New York, which is called sexual misconduct. Okay, so the higher levels of crimes are always going to be rape or criminal sexual act. Those are the two highest crimes. If you look through each of those sections and you cannot meet the requirements for each of those sections, you may have to drop the crime down to sexual misconduct. Now, sexual misconduct combines rape and criminal sexual act. So remember, for rape, it had to be sexual intercourse. For anal or oral sexual contact, it's criminal sexual act. If you can, you drop down to this lesser included offense as sexual misconduct, they both are combined under the same crime. So both those crimes can be reduced to this lesser crime of sexual misconduct. Why you would drop it down a lot of times is there's no real level of force, or sometimes you can't really show lack of consent. Those kind of things, it makes it a little bit harder to prove. So you may drop it down to sexual misconduct. Sexual misconduct also includes a section that if you have sex with an animal or a dead human being, then that also qualifies as sexual misconduct. So kind of keep in mind when you're going through your problems, if you can't get to rape or criminal sexual act, then you're going to most likely drop it down to sexual misconduct. Now, so we said rape, sexual intercourse, criminal sexual act is the anal and oral sexual contact. But don't forget, in New York, we also have touching offenses. So if it's not one of those three things, but there was touching, you may drop down to a touching offense. Now, forcible touching is touching the person in intimate parts for the purpose of sexual gratification. So if you remember when we talked about intoxication, we said it's never, voluntary intoxication is never a defense. But we said in one case it may be if you are so drunk that you cannot be sexually gratified. It could be a defense, and this is the crime that it could be a defense to. It doesn't mean they're going to get away with it. It just means you have to drop down to a sexual abuse instead. And you'll have 3 different degrees of sexual abuse to look at, and you can read the distinctions between them and see what the differences is between those degrees. We also have aggravated sexual abuse. So remember, we said aggravated was using some sort of an instrument or tool or something to touch the person with. So aggravated sexual abuse is going to fall into that category. So if they use something to do the touching, then you go into aggravated sexual abuse. Okay, so what I have posted is test your knowledge. I originally had it as a homework assignment, but I'm not going to require it as a homework assignment. I just want you to read through it and see if you can distinguish between the different levels of New York crimes. And then I posted a key, and you can compare your answers to the key and see if you're on the right track for the New York sex offenses. It's a great way to see if you truly understand the distinctions before you actually get to the homework. Okay, now to finish up sex offenses, I want to talk about some other issues that kind of come around when you talk about sex offenses. So remember, you're doing your crime, you did your crimes trends paper because you were looking at specific things, peripheral issues dealing with certain crimes. These would be some of those peripheral issues that I want to talk about. So my first question is, can you ask a woman, so if a victim comes to the police and tells them that they were raped, and then maybe they take the stand to testify against the offender, can we ask the woman on the stand how high her skirt was on the night that she was raped? Can we ask her how low her shirt was on the night that she was raped? Can we ask her how many prior sexual partners she had in the past? Can we ask how many sexual partners she had that particular night prior to the time that she was raped? So why are we asking these questions? That's what we have to ask ourselves. Why are we asking these questions in the first place? Well, basically, we're doing victim blaming, right? We're trying to blame the victim and the sexual assault on something that the victim did, okay? Oh, sorry, I missed one. How many times she had sex with the defendant prior to the rape, and how many men she had that night prior to the rape. But basically, we're victim blaming in this situation. So this was a quote when Bill Cosby was accused of sexually assaulting multiple women. His attorney said this: "I am not speculating, I'm not thinking, I'm not opining, I'm not waxing poetic, but what it says is women have responsibility. We have responsibility for our bodies, we have responsibility for our decisions, we have responsibility for the way we conduct ourselves." So in these situations, basically what is happening is we're trying to say that the victim did something that drove the offender to sexually assault the victim. That's what we call victim blaming. So when the victim of the crime or any wrongful act is accused of being partially or entirely responsible for the harm that falls on them. Now, you can see this for some other crimes, but it's very, very, very prevalent with sex offenses. So if somebody goes to an ATM and takes money out and they get robbed, we don't say, "Why did you go to that ATM? Why didn't you carry a weapon to defend yourself?" We don't tend to blame victims, but when it comes to sexual assaults, we love to blame the victim and want to point to something that the victim did that caused the sexual act to be conducted against them. We know that that's not true. So there have been laws created specifically to keep defense attorneys from asking these questions, because it's not a fair thing to ask them for sex offenses and not ask them for other crimes. So what the rape shield laws do is they limit the defendant's ability to ask certain questions during direct examination or cross-examination about the rape, specifically asking the victim about what they were wearing or prior sexual behavior or things like that. The rape shield laws also prohibit the media from publishing the victim's name if the victim does not consent, because we don't want the media publishing these names and then them like putting pressure on them or influence so that the victim wouldn't testify if they came forward. So any questions asked of the victim while they're on the stand about clothing or what they were wearing or what they were doing or what they said are probably not going to be permitted because of these rape shield laws. Now, there is an exception to this. So I gave you a bunch of different scenarios. And one of them was how many times this victim had sex with this particular defendant prior to the alleged rape. So did they have a sexual relationship prior to the rape? That might be relevant to the case. And so judges are going to possibly allow that question. The other one that sometimes they allow is how many sexual partners did you have that night before the attack? Because one of the allegations could be that the defendant could say, "It wasn't me, it was somebody else that night." So these two questions may be permitted. But what has to happen is the defendant has to tell the judge prior to trial that they're going to ask these questions. And the judge is going to hold a hearing, which is in the criminal procedure law, which is in the back of your criminal law book, your penal law book. And they're going to make a determination. Is it so prejudicial to the victim that they shouldn't be able to ask? Or is it a legitimate defense for the defendant? So the judge will have to make up that determination prior to the trial starting so that the attorneys both know whether or not they're going to be asking these questions. They still cannot ask about clothing. They cannot ask about how many prior sexual partners in general that they've had, nothing like that. Just these two specific exceptions to the rape shield law. Now, another big issue that comes up with sex offenses is the question, can sex offenders be rehabilitated? And for many, many years, the idea was you can never rehabilitate a sex offender. something in their brain that's wrong, and there's nothing you can do to rehabilitate them. There's been more research, though, in recent years that some levels of counseling and things like that can operate as a treatment to prevent future sex offenders. So that's a constant battle that exists in the legal field. Are sex offenders treatable? Is there a way we can treat them? Or should they just be punished? If we don't think there's any way we can rehabilitate them at all, we may want to just give them harsher sentences. But if we think them going through counseling and trainings and different like that, where they could be treated, then that could affect sentencing decisions either. So it's a little bit of a battle. So I posted a little video that talks about what people think. It was just a survey people did. Now, talking about punishment, what about this? Do you think that somebody should be eligible for the death penalty for a sex offense? So generally, the death penalty is reserved for the worst of the worst of the worst crimes. So you took somebody's life, then we would take yours. So homicides. So there were cases, though, that they were giving the death penalty for sex offenses. It went all the way to the Supreme Court, and Coker versus Georgia said no, that we have to reserve the death penalty for the worst of the worst of the worst cases. We're not going to give the death penalty for sex offenses. So years later, another case came up where there was a child who was raped by her stepfather and severely injured. It was an awful, awful case. So the state decided they wanted to give the death penalty for the sexual assault of a child. Went back to the Supreme Court. And again, the Supreme Court said no. They said that, again, the worst of the worst is killing, and we're going to save the death penalty only for that type of crime. So that is where that stands. Now, there is also a lot of media attention and focus on assaults on college campuses. Okay, so one of the things that they've tried to do is come up with different ways to try to limit sexual assaults on campuses. So they created Title IX, and Title IX places an affirmative duty on colleges to make sure that there's no form of sexual discrimination, real or perceived gender identity, sex, gender expression, no forms of discrimination on college campuses. And all are protected from any sexual-based discrimination, harassment, or violence. So this put on a tremendous amount of pressure on colleges to come up with ways to try to protect people on college campuses from sexual assaults. Now, there was a TED Talk that I posted that you can watch, and a group of women at a college campus decided to create like a social media platform where victims could anonymously post on a site and identify who their sexual assailants were. And that this site would report that this person is an offender, not necessarily to the police, but to the social media platform. So you can kind of watch that and get your thoughts, what you think about that. Do you think that's a good idea, not a good idea? Kind of formulate your ideas, okay? Now, another issue is what we call civil confinement. And this is your discussion for part 1 of chapter 10. And the idea is sometimes sex offenders are sent to prison, so they have a sentence. So let's say that they were sentenced to 8 years in prison. While they're in prison, they might be going to counseling and different things like that. And the correctional facility starts to believe that the person could never be rehabilitated, that they are going to reoffend when they get out. So what some states have allowed is for the prison system to have a hearing with medical advisors and things like that and determine if this person is still a threat to society. If they are still deemed a threat to society, we can't hold them in jail anymore because their criminal punishment was already set, and it would violate the Constitution to hold them longer. So what some states, including New York, have done is say, okay, well, we're not going to criminally hold you, but we're going to hold you civilly. So we're going to say it's a civil hold because of mental issues. And we're going to hold you still in a mental hospital portion of a prison. So it's kind of semantics because they're still holding the person past their sentence. Now, there have been lots and lots of challenges to this, but so far the Supreme Court and the New York Court of Appeals have upheld civil confinement. Now, they put rules around it. There has to be a hearing every year, and the doctors have to come in and say if there's any progress and things like that. But they can civilly confine the person indefinitely until the judges agree that they are no longer a threat to society. So I posted a podcast about it where they talk about this concept. So you can think about what are your thoughts about this civil confinement. Now, with sex offenses, there also is what's called Megan's Law. So this was a little girl, Megan Kenka. She was kidnapped by this super bad dude, and he sexually assaulted her and killed her. And he was living in her neighborhood. So the parents then pushed really hard. There was actually 3 court cases that dealt with this. There was the Jacob Wetterling case, and he was kidnapped and sexually assaulted and killed. So his parents pushed to create a registry of all sex offenders that are in the area so people could be aware. There was another Pan Liner case that also was part of this. And they said that the FBI is going to maintain that database of sex offenders. And then Megan's case came around, and it took those 2 previous decisions and it created what's called Megan's Law. And what Megan's Law is now a sex offender registry, where if you are charged with sex offenses, you have to register for long periods of time with the police, local police. You have to tell them where you live, where your job is, stuff like that. And so once you get out of prison, you have to report to that police station on regular bases and make sure all your information's updated. So you're going to go into this registry. And then because of Megan's Law, they made that sex offender registry have to be open to the public. So you can see that I have some websites here. If you Google sex offender registry in New York State, you can go and you can search by zip code and you can see all of the sex offenders in your particular area. For a while, schools were sending out like booklets that had all the sex offenders in that district. They aren't doing that as much. It costs a lot of money, but anybody can see that information. It's online. So you can search the New York State registry. Sometimes the individual counties or cities have it. So you can check out any sex offenders that are in your area, and that's called Megan's Law. Now, another issue that's connected to sex offenses is human trafficking or the human sex trade. I posted a really interesting video about this, of why it happens and what happens and things like that, and how prevalent of an issue it is in this country. So if you want to go online, you can watch this video. It's really sad, but you can see how people can get sucked into this human trafficking. And if you watch the video, you will see the reason why it is just so persistent and such a horrible crime. If one girl, or it could be boys too, boys are trafficked too, is trafficked, they can earn $500 a day performing sex acts for their pimp or the person that is trafficking them. If they are forced to work every day of the week, which most of them are, they are generating $3,500 per week. Now, if you multiply that by how many weeks are in a year, that one person can generate $182,000 for sex offenses. So that is human trafficking. Now get multiple girls operating all at the same time. You could be making millions of dollars a year. It has greatly contributed to the growth in human sex trafficking. So gangs and organized crime and things like that are really involved in it because they use it for money generation, which is super sad. Okay. Now, there are specific laws against this. There are international laws So the Palermo Protocols are international laws that are going to try to stop the transportation of sex trafficking across international borders. So that's out of the United Nations. There's a federal law in the United States which prohibits trafficking people across state lines. So if you're trafficking somebody across the state line, they can be charged with the federal crime of Victims of Trafficking and Violent Protection Act. And then New York has its own labor and sex trafficking. So labor is forcing somebody to perform labor for you for free, but you take their passport or something so that they cannot escape. And then sex trafficking, obviously, is for sex acts. So we have specific crimes with it in New York. So there's multiple types of crimes that the person can be charged with if they can actually be caught. And then the last thing I want to talk about is sexting. So I put a little video here that talks about it. Sexting is when somebody sends naked pictures or suggestive things in a text. Okay. Now, people can do that all they want if they're consenting adults. But remember, if you're under 17, you cannot consent. So this is mostly dealing with juveniles under the age of 17. So sometimes kids are stupid. They take naked pictures of themselves. They send them to their girlfriends or boyfriends. And then those people pass them on. That is sexting. It is a crime. It's a sex offense because it's child pornography. So if you have photographs of somebody that is under the age of 17, that is child pornography and it's called sexting. And so if you're the female taking the pictures, sending them, that's sexting. If you are the boyfriend or girlfriend and you get the pictures and you think it's funny to send to your friends, now you are distributing child pornography. So it's very controversial, though, to go after because they're usually juveniles that have it. Now, if it's an adult getting a child to do it, that's fine. But what happens a lot of times is police sometimes get involved when schools report it. And you're talking about like a 14 and a 16-year-old or 15-year-old. And then do we really want to classify a 14 or 15-year-old as a sex offender for doing something like this? So it's somewhat controversial. You don't see it being enforced that much, but it can qualify as a sex offense. Okay, so now that we've covered all the New York offenses, you're ready to put it all together. So now you need to read a scenario and you need to figure out which crimes that you would charge. So here's just a little practice problem. Harry Macho, 120-pound male, is married to Joy, a 100-pound woman, for 2 years. Neighbors often hear loud quarrels. One night he returns home after a party and finds his wife asleep. He wakes her and he insists on having sex. She refuses. She says she has a headache and she has to work in the morning. At that point, he grabs her, uses physical force, and over loud protests, he forces her to have both sexual intercourse and to perform oral sex. 2 days later, she moves out, goes to the police, tells the police what happens, and shows them the bruising. Neighbors tell police what they heard, that they heard screams that night, but they just thought that they were fighting. So when you look at this, you have to start figuring out which sex offenses in New York could you try, which could you charge. So remember, the first thing you always have to do is figure out what is the sexual act. So in this case, we have sexual intercourse as one act. We have oral sex as another act. So once we know the actual sexual acts that occur, then we can narrow down where we should be. Okay, so since we have sexual intercourse, we're going to be in the sections of rape. Now we have forcible compulsion. He forced her. We even have lack of consent because we have bruising. So we're probably going to be at a very high level of rape. Now we still have oral sexual contact. That can't be rape because it's not sexual intercourse. So for that, we have to go to a criminal sexual act. Again, forcible compulsion. And so you're going to be at a high level for that. Now, just to point out, when you're comparing rape and criminal sexual act, you will see they are identical statutes, except rape says sexual intercourse, criminal sexual act says anal or oral sexual contact. The ages, the requirements, the lack of consent, all of those things between first, second, and third degree are the exact same for criminal sexual act. So the only thing that differs between them is the sexual act that occurs, sexual intercourse or anal or oral sexual contact. So if you pick one section for rape, most likely it's going to be the same degree. I'm sorry, 1 degree for rape, it's going to be the same degree for the criminal sexual act because they're identical except for the sex act. Okay, so let's say we pick rape in the first degree. We're going to write our section down and we're going to go with subsection 1 because of the forcible compulsion. Our mens rea would be intentional. Our actus reus would be sexual intercourse with another forcible compulsion. Why? Number 1, we're choosing rape because of the sexual act that occurred. Since we had penetration, sexual intercourse, that is why we are choosing rape. Why are we choosing this degree of rape? Because there was force. You had forcible compulsion, which is first degree. So when you're choosing your degree, number 1, your sex act is going to choose what sex offense, and then you have to make sure you explain why that particular degree. Now, class, I guess I didn't do evidence here just to save, but class B felony, 1 year is the minimum, and then it's 3 to 25 years as your maximum. Now we still have another offense. We have criminal sexual act, first degree, for the oral sexual contact. So we write the section, and it's going to be exactly the same. So it's going to be intentional, except the actual actus reus is going to be oral sexual conduct instead of sexual intercourse. Same with another person, same compulsion. Why? Because it was oral sexual contact. Why first degree? Because we still had force, okay? And it even has the same class and sentence range. Now, so for proof, it kind of all goes together because you're going to use similar proof for both. So you may have a rape kit, you're going to have the victim statements, you may have bruising to show lack of consent. So those are the different things that you would have, okay? Defenses, maybe the defendant could say consent. They were married, she consented. It's probably not successful, but that might be one of the things that you would try to allege, okay? So hopefully that went well, you feel confident about it, and you're ready to do your Chapter 10, Part 1, Sex Offense Case Study. So use all the tools that we just went over and help you narrow down which sex act and then figure out which degree and then choose which sex offense you would charge. Okay, so that is the end of the second part for this week. If you have any questions, reach out. I'll be happy to help you. It can get a little confusing. So if you have any questions, just send me an email and I'll be happy to help. So I hope you have a good rest of the week, and I will see you next week, and we'll talk about assaultive offenses. See you soon.